Listen to me very carefully, because what is happening at the Supreme Court of the United States right now is not a political story. It is not a Second Amendment debate, and it is not cable news noise for you to get angry about and forget by dinner time. What is happening right now is a financial detonator sitting on a timer, and that timer expires by the end of June 2026. The justices have already tipped their hand in oral arguments. The legal direction is visible to anyone who is paying attention with a clear head and a calculating mind, instead of an emotional reaction. Two cases, Wolford v. Lopez and United States v. Hemani, are about to reshape the firearms legal landscape in a way that will send billions of dollars moving from one pocket to another in a matter of hours. The only question that matters is whether any of that money is going to end up in your pocket or whether you are going to stand there, jaw open, watching someone else collect it while you explain to yourself why you did not act. Stop scrolling. Sit down. This is the most important 30 minutes of your financial year. Before I go one word further, I need you to subscribe to this channel right now, not when the video ends. Now here's how a billionaire thinks about that request. The research, the legal analysis, the market positioning intelligence, and I am about to hand you in this video is the exact category of briefing that private wealth managers charge their clients $5,000 per session to receive. I am delivering it to you for the price of a single button click. If you cannot make that trade, you are already demonstrating exactly the kind of financial thinking that is keeping you broke. Subscribe, hit the notification bell, and let us get to work on your money. Here is what is actually happening at the Supreme Court, stripped of all the political theater and delivered to you as the pure market intelligence it is. In Wolford v. Lopez, the court accepted a case out of Hawaii where the state had passed a law barring concealed carry permit holders from bringing firearms onto private property, open to the public unless the property owner explicitly posted a sign granting permission. During oral arguments on January 20th, 2026, the majority of court justices did not merely question this law. They openly mocked its logic, with multiple justices referencing it as a so-called vampire rule, a term drawn from folklore, requiring explicit invitation before entry. When Supreme Court justices laugh at the legal reasoning of a state gun restriction during oral arguments, that is not ambiguity. That is a signal. Smart money reads that signal and moves. In United States v. Hemani, the court is examining the federal prohibition on firearm possession by users of controlled substances under Section Judy and RDR G7. Here is the number that turns this from a legal curiosity into a financial earthquake. There are 38 states in America where marijuana is now legal in some form. That means there are tens of millions of Americans who are simultaneously legal marijuana users under state law and federally prohibited persons under gun law. If the court strikes down or significantly narrows Section 92.2 G3, the immediate, direct, measurable consequence is that millions of newly legal gun buyers enter the market in a single ruling, not over a decade, not gradually. In a ruling, the gun retail sector, the ammunition manufacturers, the accessories market, the safety and storage industry, every single one of them wakes up the morning after that decision with an expanded, addressable market that did not exist the night before. I do not care about the politics of this. I do not care which side of the gun debate you stand on personally. I care about the money. And the money is telling a very specific story right now to anyone with the intelligence to listen to it without flinching. The numbers do not lie. And I need you to sit with these numbers for a moment because they are going to fundamentally change how you see this story. The firearms and ammunition manufacturing sector in the United States generates approximately $28 billion in annual revenue. The broader firearms economy, when you add retail, training, accessories, safety equipment, insurance products, and ancillary services, exceeds $70 billion annually. That is not a niche market. That is not a fringe industry. That is a $70 billion economic engine that is directly, mathematically, causally linked to the legal decisions being made at 1 First Street in Washington right now. let me give you the historical precedent, because the pattern has repeated itself with enough consistency that ignoring it is not skepticism, it is willful financial negligence. When the Heller decision came down in 2008 and the Supreme Court ruled for the first time that the Second Amendment protects an individual right to firearm ownership, the firearms industry entered a period of sustained, measurable revenue growth. FBI background check volumes, which serve as the single most reliable real-time indicator of gun purchase activity in America, climbed dramatically in the years following that ruling as legal clarity expanded the buyer pool. When Bruin came down in 2022 and the court struck down New York's restrictive handgun licensing law while establishing the historical tradition test for all future Second Amendment challenges, the legal architecture it created is the exact same. Architecture now being applied to Wolford and Hemani, Sturm Ruger and Company, one of the largest publicly traded firearms manufacturers in America, has a documented trackable revenue correlation with legal expansions of gun rights. American Outdoor Brands shows the same pattern. Vista Outdoor shows the same pattern. These are not speculative correlations invented to support a narrative. These are numbers sitting in annual reports, in earnings call transcripts, in SEC filings, available to any investor willing to spend 45 minutes reading them. The question is not whether the pattern exists. The pattern exists. The question is whether you are going to let it make you money this time, or whether you are going to read about it in a financial news article in August 2026 and feel the specific, nauseating regret of someone who knew and did not act. You are broke, and you do not even know it. And I need to say that to you directly because nobody else in your life is going to say it with the honesty it deserves. I don't care about your feelings. I care about your money. And right now, your money is telling me a story about you that is not flattering. The average American household has less than $1,000 in liquid savings. The average American carries over $6,000 in credit card debt at interest rates between 20 and 29% annually. The average American's retirement account, if they have one at all, is so underfunded relative to their actual retirement timeline that the gap between what they have and what they need is not a financial challenge. It is a financial catastrophe in slow motion. And yet, right now, while one of the most clearly telegraphed market catalysts in recent memory is sitting in plain sight, fully public, fully documented in Supreme Court oral argument transcripts that anyone can read for free, the overwhelming majority of those same Americans are going to do absolutely nothing. They are going to watch the news coverage when the ruling drops. They are going to have an opinion about it politically. They are going to maybe mention it to a coworker, and they are going to go back to their life having extracted zero financial value from an event that was announced months in advance and executed on a publicly known timeline. Stop being a victim of your own passivity. The Supreme Court does not issue rulings secretly. The cases are public, the oral arguments are public, the legal direction communicated by the justices' questions is public. Every single ingredient of this market catalyst has been available to you for months. And the only thing standing between you and a position in this trade is the habit of treating financial information as entertainment instead of as the raw material for building wealth. That habit is costing you money every single day, and today is the day it stops. Now, I want to give you the counterintuitive piece of this analysis because this is where the truly sophisticated investor separates themselves from the crowd. And this is the insight that the mainstream financial media is absolutely not giving you. Most people look at a Supreme Court gun ruling and think in binary terms. Gun rights expand, gun stocks go up, story over. But the financial reality of this ruling is significantly more layered than that simple equation. And the layers are where the real money is hiding. Consider the compliance and legal services dimension. Every time the legal landscape around firearms shifts in either direction, the demand for legal counsel, compliance consulting, and regulatory navigation services spikes immediately. Law firms that specialize in Second Amendment litigation, firearms dealer compliance, and state-level regulatory interpretation see their billing hours surge after major rulings. If you know attorneys or legal tech companies operating in this niche, you understand exactly what I am describing. Consider the insurance and liability sector. As gun ownership expands legally, the market for firearms liability insurance, concealed carry insurance, and home defense coverage products expands proportionally. Companies like USCCA, the United States Concealed Carry Association, operate in a market that grows directly in response to the legal expansion of carry rights. That is a private company, but the financial model it represents is being replicated across the insurance technology space by companies that are publicly accessible to investors. Consider the safety and storage industry. Every new legal gun owner is a potential customer for a gun safe, a trigger lock, a biometric storage system, and a range of safety accessories. The safe and vault manufacturing sector is not glamorous, but it is recession resistant. It is directly correlated with gun ownership rates, and it is sitting right at the intersection of exactly the market expansion this ruling is about to create. Winners do not just look at the obvious trade. Winners look at the entire ecosystem the obvious trade creates and position themselves across multiple points of impact. That is how you build wealth from a single catalyst instead of catching one bounce and missing the rest of the wave. Now let me give you the exact mathematical framework for how winners are approaching this. Because strategy without specificity is just motivation speech. And I did not bring you here for motivation. I brought you here for a plan. The first move is sector ETF positioning. You do not have to pick the winning individual stock in the firearms space to profit from a sector-wide catalyst. The iShares US Aerospace and Defense ETF and comparable defense and firearms adjacent ETFs give you diversified exposure to the sector direction without concentration risk in a single company. When the ruling drops and the sector moves, a diversified ETF position captures that movement without the volatility of a single stock bet. The second move is individual equity research on the three names I have already mentioned: Sturm Ruger, American Outdoor Brands, and Vista Outdoor. Pull their last 4 earnings reports. Look at the revenue lines in the quarters following the 2022 Bruin decision. Map the background check volume data from the FBI's NIC system against those revenue lines. The correlation is not subtle. It is not a coincidence. It is a business model responding to its legal environment in exactly the way a rational business model should, and that pattern is about to repeat. The third move is liquidity management. Winners have dry powder available on the day the ruling drops, not 2 weeks after when the easy money is already gone. That means right now, today, you should be identifying which positions in your portfolio are underperforming, which cash allocations are sitting idle, and what your execution plan looks like for the morning after the decision. The fourth move is timeline discipline. The ruling is expected by the end of June 2026. That gives you a defined window. Use it. Set a calendar reminder, have your brokerage account funded, have your limit orders ready. The market will move faster than your morning coffee and slower than your hesitation. And hesitation is the tax that broke people pay on every opportunity they let pass. The numbers are clear. The timeline is clear. The only variable left is you. So here is where I leave you. And I want every word of this to land with the full weight it deserves, because this is the moment that separates the people who leave this video richer in knowledge and direction from the people who leave it debt. Immediately forget everything they just heard. You have a binary choice in front of you right now, and it is the same binary choice that has defined every wealthy person who ever built something meaningful from nothing, and every broke person who ever wondered why wealth always seemed to happen to someone else. You are going to be a winner, or you are going to be a loser. The winner takes this information, does the due diligence, builds the position, manages the liquidity, and executes with discipline before June 2026 turns into July 2026, and the window closes. The loser closes this tab, scrolls to the next video, tells themselves they will look into it later, and wakes up in the second half of this year watching the financial news with that hollow, sickening feeling of someone who saw it coming and did nothing. I cannot choose for you, but I can tell you that the Supreme Court does not issue warnings. It issues rulings, and rulings move money. The only question left is whether that money moves toward you or away from you. Subscribe. Share this with one person in your life who needs to hear it, and go make your move today, because tomorrow is already one day closer too late.